Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're back for part two of that crazy defamation case from Idaho. Let's get right into it. As you may recall, when we left off, Professor Schofield had filed a complaint against this Ashley Gilliard in Texas. The complaint is actually filed in Idaho. Gilliard lives in Texas. And as a result, one of the things that happens when you get served with a complaint, you have 20 days to file an answer. Now, you can request additional time. And a lot of times, if you just call up the other attorney and say, can we agree to a stipulation that I get an extra 10 days to respond because I got a lot of stuff going on, then usually people will agree to that and courts don't have a problem with it. But if you don't get an extension of time to file your answer to the complaint, you can be defaulted. In other words, somebody can go in and ask the clerk for a default. And if the default is entered, then the next step is to get a default judgment, which means you didn't get a chance to even participate in the case because you didn't answer the complaint. So in this case, let's take a look at the docket and I will explain the series of things that have happened here. So when you log on to the U.S. District Court in Idaho, this is what shows up. Rebecca Schofield is represented by a couple of different lawyers there. And then we have Ashley represented by herself as the defendant, and Ashley as the counterclaimant, and Rebecca Schofield as the counter-defendant. And then we have the third-party plaintiff of Ashley Gilliard versus the third-party defendants of the lawyers who are representing Rebecca Schofield and also Rebecca Schofield. So this is what I would call a rather mixed up docket report, but I have a feeling it's going to get cleaned up shortly. Now we're going to get into the details that are in the docket report that go beyond the mere parties and go to some of the filings in the case. Okay, so as you can see, the first complaint here was filed in December of 2022, followed by the summons that was issued on the 22nd, and the declaration of service, which was filed on the 17th of January. Normally what you do is you get a private detective to go down and track the person down and serve the summons. So then, because the defendant did not answer the complaint within the allotted 20 days, on the 19th, the lawyers file a motion for entry of default, and then the next day, the clerk grants that entry of default. So about a month later, on the 16th of February, the defendant comes in and files an answer and counterclaims and apparently a third-party petition. The very same day, she files a motion for relief from judgment or order under the rules, which are allowed. And the very next day, the plaintiff files a response to the motion for relief from judgment and a motion for default judgment. And then it gets assigned to the magistrate judge, and the plaintiff goes and files 10 days later a motion to strike the answer and complaint and counterclaim, and a notice reflecting that. And then there is a docket entry only where all of the parties consent to the magistrate judge, and a notice by Rebecca Schofield as to the defendant's failure to comply with Local Rule 7.1. And then on the 24th of April, the court notes that all parties have consented to proceed before a magistrate judge. And then on the 26th of April, the court issues a memorandum decision in order, which we'll look at in a moment. A couple of days later, she files a notice of change of address, and the clerk files the defendant's answer to the complaint, and a third-party complaint, and a counterclaim. We'll take a look at those in probably our third video because, frankly, this video is going to be longer than I thought too. Now, tomorrow we will read the answer and counterclaim and third party plaintiff lawsuit, and we'll have some fun reading that tomorrow. But today I want to explain how we got to this point. And to do that, we're going to need to take a look at the memorandum and order. And before we get to the memorandum and order, it's important to understand that judges are constrained by certain rules which require them to give a broad intendiment to pleadings, particularly pleadings filed by third parties or by pro se plaintiffs, I should say. And it's really important to keep in mind that there is supposed to be absolutely no grace given to a third party or to a pro se plaintiff. Whether you say you're in pro puria or whether you are saying that you're a pro se plaintiff, it should make absolutely no difference whatsoever. The rules should apply equally to you as they would to anyone else. But Idaho is in the Ninth Circuit, and the Ninth Circuit has a different standard for judging one of these issues in a motion for relief from judgment. And it applies a completely different standard to a self-represented person than it does to a person represented by an attorney. And as a result of that, the judge's hands really are tied here, and we'll take a look at that right now. So before we get to the order, let's take a look at the defendant's motion for relief from judgment or order. Notice that judgment is misspelled. One would think you could afford, if you could do this, you could afford a spell checker. Now before the court is respondent's motion to reopen the case, granting her relief from the default order. She's going to claim excusable neglect here. She was overwhelmed with family obligations, right? She had, during that time, she already had a civil action pending in civil court in Harris County, representing herself, conducting research, gathering evidence, and solely prepared for both trials. In that process, she made mistakes while learning how to prepare the answer, counterclaims, and motions. After nearly 40 pages of an answer and a counterclaim, Ashley Gillard had to redo it correctly. Okay, I just have to ask, are you buying any of this? I mean, I guess I can understand where you might be unfamiliar with what to do in a court, but wouldn't you go seek out somebody who knew? Wouldn't you maybe go to Nolo Press or someplace like that online to figure out how to do this? And if you were really smart, would you not hire a lawyer? I mean, what she's saying here is enough to get the judge's attention, but she's not providing any documents or evidence. In Missouri courts, generally speaking, if you were going to make a claim like this, the court would come back and issue you a show cause order to show the documents so that the court could determine whether or not you were telling the truth or not about your supposed non-culpable neglect. Custodial parent for physically caring for a child while his dad's on military orders. She chose to support her family during that time because there's no other family to help. She goes through a lot of different things. She says that Olson and Schofield made false statements about her in a press release that was disseminated, again misspelled, worldwide to the most major news outlets across America in December. The false statements about Ashley influenced further harassment and cyberbullying. Filed a motion for entry from default. Ashley battles with combat-related post-traumatic stress disorder. Okay, that's one I want to see some documentation on. If she has post-traumatic stress disorder from combat-related causes, that should be documented in VA records. And I would suspect that one of the things that's going to come up in discovery is, you know, you've made this claim that you have PTSD. We want to see evidence of it. This is one of those things where when you're pleading a motion, you don't want to provide too much information and too much detail. And she's given them a lot of stuff to work with, which is not smart on her part. She's under an increased amount of stress. About the only thing she did not claim here is that aliens came down and abducted her. But I'm sure that if she'd given it some thought, she might have included that as well. So now let's see how the magistrate judge deals with all of this. And this is the judge's answer to the motion for relief from judgment, because that's really what's being decided here, even though he lists all of these other things. It says, in the interest of avoiding delay, because the court conclusively finds the decisional process would not be significantly aided by oral argument, these motions will be decided on the record and without oral argument. As discussed more fully below, the court will grant defendant's motion to set aside entry of default, rendering plaintiff's motion for default judgment moot. The court will also grant the access to the court filing system. So after noting it arises out of the murder, he says, in turn, plaintiff brings 2 defamation claims against defendant. One premised upon false statements regarding plaintiff's involvement with the murders themselves, the other premised upon false statements regarding plaintiff's romantic relationship with one of the murdered students. Relevant to the at-issue motion, plaintiff filed her complaint on December 21st. 6 days later, so on the 27th, defendant was served in Houston, Texas. Never responded until January 17th. A defendant must serve an answer within 21 days after being served under rule. As a result, the plaintiff moved for entry of default, and the clerk's entry of default was then entered. On February 16th, defendant filed her motion to set aside entry of default, apparently anticipating that the entry of default would be set aside. Defendant also filed her answer, affirmative defenses, and counterclaims alongside her motion for ECF access. Plaintiff responded the next day, opposing defendant's efforts to set aside and filing a motion for default judgment. Plaintiff's motion to strike followed on February 27th. Each pending motion is ripe for the court's consideration. So the court first looks at the legal standard, and it looks at a difference between the entry of a default and the default judgment. Setting aside an entry of default is simpler because it doesn't involve setting aside a judgment, which means that you get a much more lenient standard. Whether to set aside an entry of default is a matter of discretion, which means that if reasonable minds can differ, you're not going to get an appellate court to overturn it. So the thing the court must consider is whether the defendant engaged in culpable conduct that led to the default, whether the defendant had no meritorious defense, or whether setting aside the entry would prejudice the opposing party. The standard is disjunctive, such that a finding that any one of these factors is true is sufficient reason for a court to refuse to set aside an entry of default. So, the defendant, as the party seeking relief, bears the burden of showing these factors favor relief. Crucially, however, a judgment by default is a drastic step only in extreme circumstances, and a case should, whenever possible, be decided on the merits. So what do you mean by culpable conduct? Well, the general understanding of that term is you're guilty. You're guilty of doing something you shouldn't have done. One line of cases holds that a defendant's conduct is culpable if she has received actual or constructive notice of the filing of the action and intentionally failed to answer. That's the TCI case out of the Ninth Circuit. And then they quote, in this context, the term intentionally means that a movement cannot be treated as culpable simply for having made a conscious choice not to answer. Rather, to treat a failure to answer as culpable, the movement must have acted with bad faith, such as an intention to take advantage of the opposing party, interfere with judicial decision-making, or otherwise manipulate the legal process. A second line of cases suggests that if a defendant has received actual or constructive notice of an action and fails to answer, that conduct alone indicates culpability. The application of the more lenient standard for finding culpability hinges on the legal sophistication of the defendant. And I want to take a moment here to editorialize because, at least in Missouri, neither the federal courts nor the state courts apply this standard. At least they're not supposed to. A pro se applicant or pro se defendant is supposed to get exactly the same treatment as somebody represented by a lawyer. And when you apply this second standard, what you do is you encourage the filing of frivolous lawsuits by people who are not represented by counsel. It is possible to reconcile the language in franchise with the standard in TCI group when considering legally sophisticated parties' culpability in a default. An understanding of the consequences may be assumed, and with it, intentionality. Here, the defendant is representing herself pro se and is not a lawyer, so the TCI group standard applies. Defendant's explanation for failing to respond timely to plaintiff's complaint is that she has been overwhelmed with multiple civil actions and responsibilities. I'm just going to make a suggestion here that if you find yourself defending multiple civil actions in multiple different courts, maybe there's something you can do about your behavior to stop having to do that. It's just something that popped into my mind when I read that. Let's go on. The defendant specifically references how she is contemporaneously representing herself pro se in a Texas state court action, is the custodial parent to a child whose father is away on military orders, is the local next of kin to a family member who is in the hospital and on life support, recently feared for her family's safety following multiple attempts by someone trying to enter her apartment illegally, suffers from emotional distress as a result of plaintiff's claims against her, and suffers from combat-related post-traumatic stress disorder, which impacts her ability to finish tasks when under stress. According to defendant, these circumstances collectively diminished her ability to efficiently handle all the responsibilities, including timely responding to the plaintiff's complaint. Now, take a big deep breath here, because this is the part where if I was going to have problems, I would have problems. Because here's what the court says. The court takes no position on the genuineness of these claims, but acknowledges plaintiff's counterargument thereto that defendant continued her publicity-seeking commentary about plaintiff's alleged involvement in the murders even after being served with the plaintiff's complaint. The reality is, defendant spent her time posting at least 100 videos on TikTok, writing 3 blog posts, talking to reporters, recording a 40-minute YouTube video, and interacting with viewers in the comments section. If she had spent that time putting those defenses into an answer instead of boasting online to get more clicks, she could have filed a timely response. Instead, the court accepts defendant's account for limited purposes presented here. Doing so reveals the defendant admitted failure to timely respond to plaintiff's complaint was most likely an unintentional oversight caused by self-serving carelessness. Oh, wait a minute. What did you just say? Doing so reveals the defendant admitted failure to timely respond to plaintiff's complaint was most likely an unintentional oversight caused by self-serving carelessness. How can that be? It says right on the summons how long you have to answer, and it's very clear she's obviously sophisticated enough to handle a case in Harris County by herself. Certainly she knew that she had to put an answer on file here. I think the judge just kind of booted the ball here, my own opinion. And now here's something else that the court says, which I find particularly interesting. The court has reviewed the available postings referenced in plaintiff's briefing. Though off-putting and ill-advised, they reflect defendant's intention to defend the case. I'm sorry, I've looked at some of these posts, and I have to tell you, I don't think they show an intent to defend the case. I think they show an intent to get more likes and clicks on TikTok. That's just my opinion. Although the court does not condone such conduct, without more, it does not amount to bad faith with an intention to take advantage of the opposing party, interfere with judicial decision-making, or otherwise manipulate the legal process. A party seeking to set aside entry of default must present specific facts that would constitute a defense. All that is necessary to satisfy the meritorious defense requirement is to allege sufficient facts that, if true, would constitute a defense. Here, the very nature of plaintiff's claims against defendant presumes the existence of certain possible defenses. That is, to prevail on a defamation claim in Idaho, a plaintiff must prove that the defendant communicated information concerning the plaintiff to others, the information was defamatory, and the plaintiff was damaged because of that communication. but truthful statements and personal opinions in certain situations are not defamatory in the first instance. Defendant unsurprisingly takes this position in her proposed answer, Affirmative Defenses and Counterclaims. There, defendant generally submits that plaintiff's complaint fails to state a claim upon which relief can be granted, while also indicating that her allegedly defamatory statements are true. Given Kohberger's arrest and the process in the trial court that's going forward in that regard, I think I might steer clear of the whole true thing. I mean, just a suggestion here. Or otherwise not actionable. She doesn't have to establish that conclusively, and the court decides, look, because this is so early in the case, it's not prejudicial. And the plaintiff says, look, she's suffered enough harm from defendant's antics. She deserves the finality of the defendant's decision not to assert timely defenses, and she expresses frustration over defendant's disregard for procedures and deadlines. These are understandable reactions under the circumstances, but plaintiff does not actually explain how she would be hindered if the entry of default were set aside. And of course, she couldn't explain that. So as a result, the court grants the motion, grants access, denies the motion to strike, and writes the order to that effect. And it was entered on April 26, 2023. Well, there you have it. The judge is going to let her have her day in court. And in the next video, in part 3, we are going to look at basically the pleading that she filed that she thinks is an answer and a counterclaim and a cross-claim against the plaintiff's lawyers. And I will lay out some of the things that I think you can expect in some of that. So stay tuned. We'll have part 3 coming up shortly. Thanks again for watching. If you have the opportunity today, do something nice for somebody. Like, share, subscribe, you know, all that stuff. I'll catch you out here next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.